Plan on flying? It's time to upgrade to a real ID. Because in order to board domestic flights, your driver's license or state-issued ID must be a real ID, or you'll need another acceptable form of identification. So don't wait. Find out how to get your real ID at tsa.gov/realid. That's tsa.gov/realid, or visit your local DMV. And then you'll be cleared for takeoff.
Hello and welcome to Reverie True Crime. I'm your host, Paige. Are you a true crime advocate? Are you passionate about uncovering the truth and bringing justice to victims? Do you love the paranormal and spooky tales? Then you will not want to miss the True Crime and Paranormal Podcast Festival taking place in Austin, Texas from August 25th to the 27th, 2023. This festival features panel discussions, workshops, and live podcasts with a special focus on ethics and advocacy in the true crime sphere. Get your attendee or attendee VIP tickets at truecrimepodcastfestival.com and get 15% off with promo code REVERIE, REVERIE. Join us in Austin, Texas for an unforgettable experience. Don't miss out on the chance to connect with other advocates and take your passion for true crime and the paranormal to the next level. So book your attendee or attendee VIP tickets today at truecrimepodcastfestival.com with promo code REVERIE for 15% off. Come be a part of this amazing event. Special guests include Julie Murray, Tara Newell, and Collier Landry, to name a few. We hope to see you there. Today's episode is a listener suggestion from Luke, and this case is out of Arkansas. A very well-known and loved teacher was the victim of a murder-for-hire scheme. I dug up every bit of information I could find. Thank you so much to Luke for bringing this case to my attention. If you'd like to suggest an episode, please don't hesitate to reach out to me on Instagram or Facebook at Reverie True Crime, Twitter at Reverie Crime Pod, or email me at reverietruecrime@gmail.com. Let's jump right into this episode. William, known as Bill, Dyer was 47 years old and married to 47-year-old Glenda Blanchard Dyer in 1998. From what I could find, Bill was born on December 24, 1950 in Texarkana, Texas to Dora Dyer, and he had 3 sisters, Linda, Edna, and Mary. Bill was also a member of the First Baptist Church of Horatio. He had 1 grandson, many nieces, nephews, and great-nieces and nephews. Bill was a beloved, popular agriculture teacher in Horatio, Arkansas at Horatio High School. He worked there for 22 years, and all of his students were crazy about him. Glenda worked at a nursing home. They had 3 lovely daughters together, Nikki, Jody, and Kelly. 2 were in college in 1998, and 1 was living at home. On December 4th, 1998, Bill's life was cut short. Bill and Glenda's 18-year-old daughter, Kelly, got home that day a little after 6 p.m. and found her father's body in their driveway. There was not any blood that she could see, and she thought he may have had a heart attack. After calling 911, she and her family would learn this was no heart attack. From the start, police knew this was not a suicide or a tragic accident. Bill had been shot 1 time in the neck with a .30-30 high-powered rifle while he was inside of a deserted farmhouse on his property. The one thing people were thankful for is that it was determined he more than likely didn't suffer at all. The fatal bullet went into his neck and severed his spinal cord, which without a doubt killed him instantly. Investigators did discover a shell casing inside of the farmhouse. It was lying about 100 feet away from where Bill had been shot. Bill's funeral was held at the Horatio High School's gym, and over 1,000 people showed up to say their final farewells to the man who was so respected and adored by them all. When authorities started investigating, 12 days in, they had questioned 50 people, conducted lie detector tests, and had no suspects or motive. Bill had not been receiving any threats by anyone, and he didn't have any enemies that anyone was aware of. On January 1st, 1999, Bill's wife Glenda called authorities, saying someone had broken into her house around midnight. The sheriff said Glenda did not see or hear anything, but when she woke up, she was on the kitchen floor. The intruder did not steal anything from the home, and the police said it was all really bizarre. Police revealed that since the night of Bill Dyer's murder, Glenda had been a suspect. Authorities reported that one of Glenda's co-workers at the DeQueen nursing home was paid off by someone to shoot Bill Dyer. Stephen Swim was the person who was blamed for the shooting. He was scheduled to take a polygraph test on March 3, 1999, but on that day, he took his own life by shooting himself in the chest with a shotgun. Glenda told police her husband's gun was nowhere to be found, and she believed he might have been shot with his own gun, the .30-30 rifle. Not long after all of this, police reported that, allegedly, Bill's wife Glenda hired Stephen to take her husband out. She was charged as an accomplice to first-degree murder, which means she either solicited, encouraged, aided, or attempted to aid Stephen Swim, who was accused of shooting Bill Dyer. Sheriff John Partain said, quote, "We believe Stephen Swim was promised money for his involvement in the murder." On March 12, 1999, prosecutor Tom Cooper told the Times about Glenda's charges and said she was being held at the county jail on a $250,000 bond. If Glenda was convicted of this crime, she would be looking at 10 years to life in prison. In July of 1999, Glenda was still awaiting her trial. It was scheduled to take place in September of 1999 outside of Sevier County. Sevier County Sheriff John Partain stated, quote, "Money was likely the motive, money and life insurance." All three of Bill and Glenda's daughters filed a $1 million lawsuit against their mother for wrongful death. The trial was in Pike County, where she was ultimately convicted of first-degree murder of her husband, Bill Dyer, and sentenced to life in prison on September 29, 1999. A lot is uncovered about the trial and Glenda's appeals. Also, a few years later, we hear from Glenda's good friend and more from her and Bill's daughters. So let's go through all of it. This is from her appeal in January of 2001. On appeal, Glenda Dyer argued that the trial court made a mistake by, number 1, admitting statements made by a co-conspirator, number 2, denying her motion for continuance to obtain an independent mental evaluation, and number 3, admitting testimony from 6 witnesses concerning prior threats made by Glenda. We find no error and affirm. Number 1. Statements of co-conspirator. For her first point for reversal, Glenda argued that the trial court made a mistake in admitting testimony from Stephen Swim's wife, Sylvia Swim, and her son, David Swim, concerning statements that Stephen made to them. Collectively, Stephen told them that a blonde woman in her 40s would bring them some money, $10,000 to $15,000, as payment for Stephen's role as a hitman. The trial court allowed statements by a co-conspirator made in the course of and in furtherance of the conspiracy. Glenda challenged the trial court's finding that 1. She and Stephen were involved in a conspiracy to kill Bill Dyer, and 2. The statements were made by Stephen Swim in furtherance of the conspiracy. A statement is not hearsay if it is offered against a party, and it is a statement by a co-conspirator of a party made during the course and in furtherance of the conspiracy. Before such statements can be admitted, the state must make a prima facie showing that a conspiracy existed between the declarant and the defendant. Number 1. The statements themselves may be considered along with other independent evidence in determining the existence of a conspiracy. The sufficiency of the evidence of a conspiracy is a preliminary matter decided by the trial court. As with any other evidentiary matter, we will not reverse the trial court's ruling absent an abuse of discretion. In the present case, the trial court found that the state had made a prima facie showing that a conspiracy to kill Bill Dyer existed between Glenda and Stephen. The state presented evidence that Glenda and Stephen worked together at the regional care facility in DeQueen. Glenda was Stephen's supervisor. About 1 month prior to the murder, Debbie Hibbs, a co-worker who was also Stephen's girlfriend, overheard Glenda say to Stephen that she wished she knew someone that could kill her husband. Stephen replied that he might know somebody that could help her, and then just kind of laughed. Glenda made numerous other threats and statements regarding her desire to be rid of her husband. For instance, she had previously made inquiries about killing her husband with poison so that his death could not be traced to her. She also made the statement that the only way she could get out of her marriage was if her husband were dead. Medical evidence showed that Bill Dyer had been killed by a high-powered rifle shot to the neck. Investigation of the scene revealed that the fatal shot was likely fired from inside an old farmhouse situated on the Dyer's property. Police found a bullet hole in the screen of the farmhouse window and an expended shell casing nearby. Less than 2 months prior to his murder, Bill discovered that one of his rifles, a .30-30 caliber Winchester hunting rifle, was missing. David Swim, Stephen Swim's son, testified that Stephen was not a hunter and did not own a gun. About 1 month prior to Bill's murder, however, Stephen somehow obtained possession of Bill's missing rifle. Jason Hibbs testified that sometime in late October or early November of 1998, he discovered a .30-30 hunting rifle in Stephen Swim's toolbox. Jason took the gun hunting and also fired it in his father's backyard. Shell casings recovered from that location were given to the police. In turn, the police sent them to the state crime laboratory to be compared against the shell casing found at the crime scene and some casings found in the victim's gun cabinet. Ballistics testing revealed that all of those shell casings were fired from the same gun. The month before the murder, right around the time that he obtained possession of Bill's rifle, Stephen Swim told his wife Sylvia not to worry about money because there is a woman in her 40s that will, quote, bring you some money, about $15,000. When Sylvia asked why, Stephen told her that whatever happened, she would hear about it on the radio. Similarly, Stephen told his stepson David that a blonde lady in her 40s would bring them a bag of money, $10,000 to $15,000. When David asked why, Stephen told him it was for being a hitman. Prior to his suicide, Stephen told his wife that the woman in her 40s was Glenda Dyer. On the date of the murder, Glenda was working at the regional care facility with Stephen. Late in the afternoon, Glenda left work for the purpose of retrieving Christmas decorations from her house to bring back to work. Around 3:15 or 3:20 p.m., Glenda was seen at the DeQueen High School talking to her husband, who was a teacher there. Two students observed Glenda in her white Ford pickup truck near the school parking lot. Inside the truck, slumping down in the passenger seat, was a man who appeared to be trying to hide his identity. The man had facial hair and was wearing a black leather jacket. Other evidence showed that Stephen Swim had facial hair and wore a black leather jacket. Between 4:10 and 4:15 that same afternoon, a witness saw Glenda driving her white Ford pickup truck towards her house in Horatio. Around the same time, Glenda's neighbor observed a white Ford truck of the same make and model as Glenda's driving in the direction of her residence. The neighbor heard a gunshot a short time later and then saw the white Ford truck drive away from the residence. During this same time, co-workers noticed that both Glenda and Stephen were absent from work. Additionally, Stephen's wife telephoned the regional care facility looking for Stephen around 4 o'clock, but he was not there. Both Glenda and Stephen returned to work later that afternoon. Bill's body was discovered by his daughter Kelly around 6 p.m. Kelly then called Glenda at work and told her that something was wrong with her dad. Kelly never told Glenda that Bill was dead. However, upon receiving the phone call, Glenda became hysterical and started screaming, quote, "He's dead! He's dead!" On February 1st, 1999, around the time that the police investigation began to focus on him, Stephen attempted suicide by drug overdose. 1 month later, on March 3rd, 1999, Stephen was scheduled to take a polygraph regarding Bill's murder. He never showed. The next day, Stephen's body was found in a concrete culvert near his home. Stephen left a note to his wife saying that he could not take the pressure anymore. According to the medical examiner, the official cause of Stephen's death was suicide by a single shotgun blast to the chest. After his suicide, Kelly Dyer began to suspect that her mother had put Stephen up to committing the murder. As a result, she began to prod Glenda about her role in the murder. One day, in front of her two sisters and her aunt, Kelly asked Glenda, quote, "How did you get Stephen to kill our dad?" Glenda did not deny playing a part in her husband's murder. Instead, she rather calmly responded that she did not do anything that her daughters did not want done before. After Stephen's suicide, his wife Sylvia went to the police and told them about the statements that her husband had made to her and David regarding the money that Glenda was supposed to bring to them. At the direction of the police, Sylvia had conversations with Glenda on the telephone and in person about the money. During one of those conversations, Sylvia informed Glenda that her son David knew everything about the murder. According to Sylvia, Glenda became very upset and responded, "David knows?" Glenda then assured Sylvia that she would give her money, but that she could not get the insurance money until her name was cleared. Glenda told Sylvia in no uncertain terms, quote, "If I go down, there is no money." Other evidence showed that Bill Dyer was insured for over $200,000 and that Glenda was the primary beneficiary of the policies. Additionally, at the time of the trial, Glenda was receiving Bill's retirement pay, which was approximately $1,680 per month. In light of the foregoing evidence, we conclude that the trial court did not make a mistake in finding that there was a prima facie evidence of a conspiracy between Glenda and Stephen to kill Bill Dyer. We conclude further that the statements made by Stephen to his wife and son were made during the course and in furtherance of the conspiracy. In the first place, the statements were made during the course of the conspiracy, as they were made prior to Bill's death, sometime during November 1998. This is near the time that Stephen obtained possession of Bill's rifle and was overheard talking to Glenda about killing her husband. In the second place, the statements were made in furtherance of the conspiracy. Although this court has had few opportunities to discuss the, quote, "in furtherance of" element, it has held the statements designed to further the specific objective of the conspiracy are made in furtherance of the conspiracy. Federal cases interpreting the corresponding federal rule of evidence hold that this requirement should be interpreted broadly. Moreover, statements that are designed to enlist a third party's assistance or to induce the listener's aid in achieving some objective of the conspiracy meet the "in furtherance of" requirement. Glenda Dyer relies heavily on the case of Leach v. State of 1992, in which the Court of Appeals held that statements made by a co-conspirator to his wife, who was not part of the conspiracy, were not admissible under Rule 801. Leach relied primarily on two federal cases which held that statements made by a co-conspirator to his wife were not made in furtherance of the conspiracy, where the statements were nothing more than a report of the co-conspirator's activities or casual admissions of culpability. While we do not dispute the legitimacy of these holdings, we conclude that the present case is distinguishable. Here, the statements made by Stephen Swim to his wife Sylvia and stepson David may be viewed as being designed to enlist their assistance or to induce their aid in achieving one of the objectives of the conspiracy, namely the receipt of payment from Glenda to Stephen's role as a hitman. Notably, Stephen's statement to his wife was that a woman in her 40s, later identified by him as Glenda, would bring, quote, "you," meaning Sylvia, some money. Similarly, the statement to David was that the money would be brought to, quote, "us," meaning the family. Thus, the statements had the effect of involving Sylvia and David in the conspiracy as far as collecting payment for Stephen's participation. Accordingly, we cannot say that the trial court abused its discretion in finding that the statements were made during the course and in furtherance of the conspiracy to kill Bill Dyer. Number 2. Continuance to obtain independent mental evaluation. For Glenda's second point for reversal, she argued that the trial court made a mistake in denying her motion for a continuance so that she could obtain an independent mental evaluation. The record reflects that Glenda received a court-ordered mental evaluation to determine whether she was competent to assist in her trial. She then filed a motion for an independent evaluation on the ground that the report from the first evaluation contained inaccurate information, such as listing her husband's name incorrectly. Glenda also filed a motion for continuance until the independent evaluation could be done. The trial court denied the continuance for 3 reasons. Number 1, Glenda was not diligent in seeking an independent evaluation. Number 2, there was no evidence that she had a history of mental illness or was otherwise not capable of assisting in her defense. And number 3, her claim that the psychologist's report contained inaccuracies was self-serving. Glenda now contends that the trial court's ruling was erroneous. We disagree. This court has repeatedly held that the grant or denial of a continuance is within the sound discretion of the trial court, and its decision will not be reversed absent of an abuse of discretion amounting to a denial of justice. The following factors are to be considered by the trial court. Number 1, the diligence of the movant. Number 2, the probable effect of the testimony at trial. Number 3, the likelihood of procuring the attendance of the witness in the event of a postponement. And number 4, the filing of an affidavit stating not only what facts the witness would prove, but also that the appellant believes them to be true. To demonstrate error on appeal, Glenda must show that she was prejudiced by the trial court's denial of the continuance. When an accused raises the defense of mental disease or defect, or places his or her competency in issue, the trial court must follow the procedures for evaluation. An evaluation performed under Section 52305 does not ordinarily require a second opinion, and further evaluation is discretionary with the trial court. In other words, the state is not required to pay for a defendant to shop from doctor to doctor until he or she finds one who will declare him incompetent to proceed with his trial. Indeed, the law is well settled that an accused is presumed competent to stand trial, and the burden of proving incompetence is on the accused. Here, the record reflects that Glenda sought and was granted an evaluation. She was then evaluated by Dr. Lillian Cheney, a psychologist in Hot Springs. During the hearing below, Glenda's attorney explained that they had initially sought an evaluation because there was some question as to whether Glenda, who was under medication and had experienced some memory loss, was able to aid in her defense. Although the report is not contained in the record, we may presume that Dr. Cheney determined that Glenda was competent to proceed with her trial. In denying the motion for continuance, the trial court emphasized that Glenda had not been diligent in attempting to get a second evaluation. The record demonstrates that Dr. Cheney's report was received by the defense on August 30th, 1999. However, no request was made for an independent evaluation until September 16th, 1999. The trial court pointed out that Glenda had private counsel and her own source of funds, such that she did not need a court order to obtain a second evaluation. The trial court also noted that the state had offered to assist in providing funds for an independent evaluation. Moreover, the trial court found that the delay requested by Glenda was due to her psychologist's schedule and was not related to the length of time necessary to complete the tests, which the psychologist testified could be done in 2 or 3 days. Additionally, the trial court was not persuaded by the legitimacy of the reasons given for the second evaluation. There was simply no evidence offered by Glenda that she had actually suffered from a mental disease or defect or was otherwise incompetent to stand trial. Rather, the reasons given for the second evaluation was to correct factual inaccuracies contained in Dr. Cheney's report, such as the name of Glenda's new husband and the location where they were married. Neither the motion for the second evaluation nor the testimony of the defense's psychologist asserted that Glenda was not competent to stand trial. Moreover, Glenda's defense was one of general denial and was not based on a claim of mental disease or defect. Accordingly, Glenda has failed to show that she was prejudiced by the trial court's denial of her motion for continuance. We thus cannot say that the trial court abused its discretion. 3. Prior threats. For Glenda's last point for reversal, she argued that the trial court made a mistake in admitting testimony of her prior bad acts and statements made by her about killing her husband. The evidence in question came from 6 witnesses. The first, Brenda Cranford, testified that during the warm months of 1997, Glenda asked if Brenda, quote, had any knowledge of how she could do away with Bill and there not be any trace to be traced back to her, such as poison, pesticides, and things like that. Brenda Cranford stated that approximately 4 to 6 weeks after Glenda's question, Bill Dyer was hospitalized. Busta Willis testified that during the fair season of 1998, Glenda had confided in him that she and her boyfriend had been caught in an extramarital affair by her boyfriend's wife. According to Busta, Glenda stated that her boyfriend's wife told her that she was going to tell Bill about the affair. When Busta asked Glenda if she was going to get out of her marriage, she stated that the only way that she could get out of it was if her husband were dead. Debbie Hibbs, the girlfriend of Stephen Swim, not his wife Sylvia, testified that about 1 month prior to the murder, she overheard a conversation between Glenda and Stephen. According to Debbie, Glenda said she wished she knew someone that could kill her husband, and Stephen said, I might know somebody that can help you, and then they just kind of laughed. The remainder of the challenged testimony was provided by Glenda's 3 daughters. Kelly Dyer, the youngest daughter, testified that she suspected her mother's involvement in her father's murder because Glenda had, quote, made threats before that she wished my dad was dead and that she was going to kill him. Kelly stated that within 3 years prior to the murder, one of her mother's boyfriends, a farmhand that had lived with the family, asked Kelly if she would move away with him and Glenda if they were to get rid of her father. Kelly stated that they were talking about making it look like a farming accident so they could collect more insurance money. Kelly also described an incident involving a glass of iced tea prepared for her father by her mother. Quote, "My mama told me before that she was going to get rid of Dad, and a week later we were eating supper and Dad drank some tea, and he took a drink of it and said, 'Something's wrong with this tea.' And I was like, 'Well, let me taste it.' And he handed me the glass of tea. And Mom jumped up and grabbed it. And she said, she took it from me and she went towards the sink with it and she acted like she took a drink of it and she dumped it out. And she said, 'Nothing's wrong with this tea. I don't taste anything.' And later that night, Dad, after we finished supper, Dad got up and he was real pale, and he laid down on the couch. He got up later off the couch and he collapsed on the concrete and busted his head open." End quote. According to Kelly, her father was hospitalized that night. This was the same period of hospitalization described by Brenda Cranford. Jody Dyer, Glenda and Bill's middle daughter, testified about an incident that occurred when her mother worked for a doctor in DeQueen. Jody stated that one afternoon when she stopped by the office, she saw her mother and Dr. Brown talking. Jody stated that prior to that date, she had had an argument with her father that resulted in her being disciplined. According to Jody, Dr. Brown told her that she should not have to put up with her father's discipline and that they could kill her father, quote, "by giving him a pill that would speed up his heart and it would look like a heart attack and nobody would ever know." In response to Dr. Brown's statement, Glenda asked Jody if she would tell anybody if that happened. Jody responded that she would. Jody also testified about an incident involving one of her former boyfriends in which her mother told her that she knew the boy hunted a lot and was good with a gun. Glenda then asked Jody, quote, "Why don't you ask him if he would go hunting with your dad and make it look like an accident?" Lastly, Glenda and Bill's oldest daughter, Nikki Harris, testified that during the 3 years before the murder, her mother made ongoing threats about killing her father. On one of those occasions, she informed Nikki that her boyfriend, Chuck Lang, quote, "knew people and that he could have him killed or knew how she could get stuff to kill him." Nikki also described an occasion in which her mother stated that if she killed her husband, she would not feed the family's pigs for several days so that she could then dispose of Bill's body by throwing it in the pen where the pigs would eat him. Glenda objected to the foregoing testimony on the ground that the acts and statements were too remote and that the probative value of the evidence was substantially outweighed by the danger of unfair prejudice. The trial court allowed the testimony but limited the state to acts or statements that occurred within 3 years prior to trial. On appeal, Glenda argued only that the trial court's ruling is erroneous under Rule 403. There is no merit to this argument. Rule 404B provides, "Evidence of other crimes, wrongdoings, or acts is not admissible to prove the character of a person in order to show that he acted in conformity therewith. It may, however, be admissible for other purposes, such as proof of motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake or accident." The test for admitting evidence under Rule 404B is whether evidence of the other act has independent relevance. Evidence is indisputably relevant if it proves a material point and is not introduced solely to prove that the defendant is a bad person. Although evidence may be relevant under Rule 404B, it nonetheless may be excluded under Rule 403 if its probative value is substantially outweighed by the danger of unfair prejudice or confusion of the issues. Trial courts have broad discretion in deciding evidentiary issues, including the admissibility of evidence under Rules 403 and 404b, and those decisions will not be reversed absent an abuse of discretion. Glenda was charged with having killed her husband alone or in conjunction with Stephen Swim. It was the state's theory that Glenda did not actually commit the act that killed her husband. Rather, the state alleged that Stephen fired the shot that killed the victim, but that he had done so at Glenda's request. It was thus crucial to the state's case to show Glenda's intent or motive to kill her husband. As this court has held, intent or state of mind is seldom capable of proof by direct evidence and must usually be inferred from the circumstances surrounding the killing. Thus, threats made by a defendant prior to the time a homicide occurred are admissible to establish motive and ill will, even where they are never communicated to the victim. The court held that there was no error in admitting testimony that 2 years prior to the murder of her husband, Glenda had asked the witness if he knew anyone that she could hire to kill her husband, for which she would pay $10,000 to $30,000 from the insurance proceeds. This court held the testimony was properly admitted in evidence. Threats, although not communicated to Bill, are admissible as tending to show ill will and motive. Remoteness in time is to be considered when the interval between former difficulties and the homicide is so great as to indicate that they had their origin in independent causes. In McElroy v. the State in 1911, we upheld the admissibility of threats made about a year and a half before the homicide. Underhill points out, with regard to proof of marital difficulties, that the fact that such troubles cover a period of years and continue down to the death strengthens such evidence. In the present case, Glenda's prior threats to kill her husband were highly probative of her ill will toward him and her motive or intent to kill him, especially since she had evidently succeeded in her threats. They further demonstrate her willingness to solicit others to carry out her plans, just as she had done by getting Stephen Swim to commit the murder. We agree with the state that the probative value of the prior threats is strengthened by the fact that they were made throughout the 3-year period preceding the murder, thus establishing a continuing course of conduct that persisted until the victim's death. Furthermore, the testimony offered by Kelly Dyer about her mother's apparent attempt to poison Bill was highly probative of Glenda's motive and intent to kill him. We thus conclude that the trial court did not abuse its discretion in ruling that the probative value of this evidence was not substantially outweighed by the danger of unfair prejudice to Glenda Dyer. From Glenda's appeal in April of 2003. Glenda said when the jury found her guilty, the focus should have been shifted to going forward with any evidence that would aid her in receiving a sentence less than the maximum of life. According to Glenda, there was mitigating evidence when it came to testimony provided pertaining to Bill being physically and verbally abusive towards her. According to Glenda's attorney, counsel said during the guilt phase of the trial that he made the decision not to present evidence concerning abuse. The attorney's reasoning was that Glenda's defense was in complete denial and evidence of abuse would have given Glenda a motive for killing her husband. Counsel also stated that he and Glenda discussed possible sentencing phase witnesses before trial, and they decided together which witnesses to call. According to counsel, the decision was made that Glenda would not take the stand because she would be cross-examined regarding sexual affairs she had before and after her husband's death, and because other witnesses were available to provide relevant testimony. Counsel also testified that the trial judge explained to Glenda that she had the right to testify and she waived that right. Glenda contends that evidence of her sexual affairs had already come out during the guilt phase. Therefore, it would not have mattered that putting her on the stand would have opened the door to such testimony. In denying Glenda's petition, the trial court found Glenda Dyer now relies on hindsight concerning what witnesses she wished to be called, as well as the content of witnesses' testimony and the failure of her attorney to ask more questions of certain witnesses. She admits in this hearing she did not want to destroy the reputation of her husband at the trial, and therefore made a decision with her attorney not to bring out any testimony concerning abuse or threats. The defendant also had a problem with presenting inconsistent defenses. On one hand, she wants to complain about how she was treated by her husband, the victim, and implies some mitigation as to why she would play a part in his death, and on the other hand, claims no part whatsoever in the planning and carrying out of the murder. According to the trial court, Glenda chose not to ask questions of certain witnesses to avoid drawing the jury's attention to her sexual affairs, and that she chose not to question witnesses regarding the abuse. Finally, the court found that with counsel's advice, Glenda decided not to testify. The trial court concluded that such decisions were, quote, pure and simple trial tactics and strategy, and thus are not grounds for relief under Rule 37. We agree with the trial court that matters of trial strategy are not grounds for a finding of ineffective assistance of counsel. The decision of whether or not to call a witness is generally a matter of trial strategy that is outside the purview of Rule 37. Trial counsel must use his or her best judgment to determine which witnesses will be beneficial to his client. When assessing an attorney's decision not to call a particular witness, it must be taken into account that the decision is largely a matter of professional judgment that experienced advocates could endlessly debate, and the fact that there was a witness or witnesses who could have offered testimony beneficial to the defense is not in itself proof of counsel's ineffectiveness. Nonetheless, such strategic decisions must still be supported by reasonable, professional judgment. Because counsel's decisions were matters of trial strategy that did not fall beyond the scope of what a competent attorney would recommend, we find no basis for a claim of ineffective assistance. Accordingly, we affirm the trial's denial of post-conviction relief. In January of 2005, the Texarkana Gazette reported, an Arkansas Department of Corrections official said a post-prison transfer board member will hear Glenda Dyer's request for clemency, and the entire board will make a recommendation by January 18, 2005. A member of the post-prison transfer board will interview Glenda Dyer at the ADC McPherson unit in Newport, Arkansas today, said Rhonda Sharp, spokesman for the board. If the board finds her application with merit, it will then remain up to Governor Mike Huckabee to decide whether to grant Glenda Dyer clemency. Little Rock resident Carolyn Voss is a lifelong friend of Glenda Dyer's. She had planned to attend that hearing and to hopefully speak on her friend's behalf. Carolyn Voss said she has always believed Glenda is innocent. Quote, "She couldn't kill a snake, let alone a human being. She is a good person. She would help society much more out of prison than in prison." Carolyn said that growing up, she spent a lot of time at Glenda's home. Quote, "We were best friends, and I still consider her one of my best friends. There is no way she would ever take someone's life or hire somebody to take someone's life." But family members of Bill Dyer, including the couple's 3 daughters, hoped that Glenda Dyer finished out her prison sentence, and they told the board members so at a recent victims' input hearing in Little Rock. Glenda and Bill's daughter, Nikki Dyer Litchford, told the board, quote, "Our mother's actions were wrong. She broke our hearts. There is nothing we can do to change what has happened, but as our father's daughters, we cannot sit by and do nothing." Nikki is Glenda and Bill's oldest daughter. She addressed the board and read a letter signed by herself and her 2 sisters. Nikki said, quote, "You as a parole board cannot fix this wrong that has been done to us, but you can reflect on our decision to do the right thing and be the kind of people our dad taught us to be." Around 20 relatives and friends of Bill Dyer attended the January 5th Victims' Input hearing in Little Rock. Both Nikki and Mary Dyer Galloway, who is Bill's youngest sister, spoke to the board. Nikki said, quote, "We don't know if any of you have lost a parent, but the pain is horrible. You never, never, never stop hurting for them. Their oldest grandson is 7, the only child either of them got to know, and every time he puts his boots on with his pants stuffed down in the tops, just like his pop-pop, we wish he were here." Bill's sister Mary told the board how her brother's death and Glenda Dyer's subsequent arrest and conviction had affected the family, including the health of her 83-year-old mother. Of her and Bill's mother, she said, quote, "I live not far from her and have personally witnessed her health deteriorate more quickly with each travesty that occurs and could have been prevented. She has had enough pain and suffering from Glenda. I feel that if Glenda is released, that my life would be in danger and my mother's life would be tormented daily by Glenda's causes." Nikki said that even if her mother was free, she and her sisters would not want her in their lives. Nikki said, quote, "How can you forgive a person who has never asked for your forgiveness? Do we want her in our lives if she were free? If she could plan out and execute the murder of our father, what would stop her from planning the murders of her children or grandchildren? We would be in constant worry that she could harm us or our family." Unfortunately, I couldn't find anything past 2005. However, I did look Glenda up in the Arkansas Department of Corrections database, and she is still serving life in prison for first-degree murder in the McPherson unit in Newport, Arkansas, as of February 22, 2023, and I'm sure Bill's daughters and other family members will always fight to keep it that way. Thank you again to Luke for bringing this case to my attention and suggesting that I look into it. And thank you all so much for listening to this episode. Until next time, everyone, please stay safe, take care of yourselves and each other.